Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Okay. Shall I start again?
Good morning, everybody. I'd like to say I'm very happy to have you back, and it's a pleasure again to receive Professor Pierre Dagen. I'd like to address my warmest welcome to Professor Pierre Dagen. Professor, thank you.
Thank you very much, dear colleague Luis. It's a pleasure to be back, ladies and gentlemen. Today I will cover the intrinsic modalities of international obligations. You remember that yesterday I covered the extrinsic modalities by distinguishing between bilateral obligations and collective obligations. And let me just remind you that the extrinsic modalities of international obligations are not simply about the relationship between the bearer of the obligation and the corresponding right holder, the distinction between bilateral and collective obligation goes beyond that. It's a distinction that is more broadly about the legal interest that exists in requesting compliance with the obligation. And that legal interest is broadened in terms of the subjects that may request compliance when we meet a collective obligation, whether it's an erga omnes obligation or an erga omnes partes obligation. And within erga omnes partes obligations, we made the distinction between integral obligations and interdependent obligations. And as I said yesterday, the emergence of collective interests in international law is really a turning point in the construction of the legal order for the world. It's really the passing from a legal order concerned with coexistence to a legal order concerned with cooperation between states and taking over global concerns. Now, I would like to turn today to intrinsic modalities. And the intrinsic modalities of international obligations concern the way in which the obligation binds the subject that owes the performance of that obligation. And it is important to identify the intrinsic modality of each obligation, because it will help us to determine what counts as a breach of the obligation. The breach of an obligation being defined in Article 12 of the Articles on State Responsibility, being defined as an action or an omission that is not in conformity with what is required by the obligation. Well, to know what is required by the obligation is therefore important. And my submission is that, of course, every obligation is different. And of course, you need to interpret the rule that contains the obligation, or that contains various and several obligations, because the different obligations may be contained in the same rule. And when you interpret the rule, you will discover those obligations. And of course, this is a matter of interpretation according to the various rules that apply to the various instruments of international law, the various norms. And my submission is that this interpretative exercise of discovering what the obligations are under the rule does not occur in a mental vacuum. My submission is that we have some kind of mental framework that will guide the interpretation, and that will end up finally into deciding whether the obligation is a positive or a negative obligation, or if it is an obligation of conduct or an obligation of result. And my submission is that at the end of the day, all those interpretations will lead to somehow finding that the obligation is either positive or negative, or of result or of conduct. And knowing, as I said yesterday, that when you combine, you can have only negative obligations of results, while you can have positive obligations of result or of conduct. And I will explain what's the difference between an obligation of result and an obligation of conduct. And I'll turn to that. But this is my submission, and my submission is that this typology and the difference between positive, negative, conduct or result really reflects very basic human behavior. As we know, states are abstract entities. As we know, international organizations are abstract entities also, but of course they behave, their conduct is the result of human behavior that needs to comply, to conform with what is required under the obligation. And this issue of conforming with the obligation will always lead to having to decide what type of behavior is required by the obligation. And my submission is that the behavior, the human behavior of the agent of the state or the agent of the organization will be either an abstention or an action, positive or negative obligation, or it will be an obligation, and combined with that, it will either be an obligation to try to do the best you can, or an obligation to achieve something. Okay, and it can be achieving something by abstaining, or it can be achieving by doing something. Okay, and let me come to that. But those distinctions, I think, really reflect. Again, law is common sense. Okay, law does not grow outside of common sense, and it always relates to human relations and to human behavior. Okay, and when you go to the substance of it, well, what do we do in life? We either do things or don't do things. And we either do things in order to achieve something that is required, or we do things the best we can. And those are degrees of behavior, in a way, differences in terms of behavior. Let me take first the distinction between positive and negative obligations. And I will first try to explain the distinction, and then I will give you a few hints in the law of state responsibility to explain why the distinction, I think, is important to make. A positive obligation is an obligation that is violated, breached, by a failure to act. Either the failure to act is total, somebody must do something but doesn't do anything at all, or the failure is only partial. You do something, but you do not do something enough, okay? You should have done more, okay? In both cases, the wrongful act, the conduct that is in breach of the positive obligation will be what is called an omission, okay? It is an omission. You fail to do something that you should have done. By contrast, a negative obligation is an obligation that is violated, breached by a positive conduct. That is something that you can observe in the real world, okay? For instance, if you have an obligation not to kill, well, killing is the breach of the negative obligation not to kill, okay? So a negative obligation is an obligation to abstain from doing something that is physically possible, okay? But you ought to abstain from behaving. For instance, the obligation not to commit genocide is a negative obligation. The obligation to prevent genocide is a positive obligation. You have to do something to prevent genocide from occurring, okay? Or, for instance, the prohibition of complicity in genocide, okay? There's also a prohibition of complicity. That is a negative obligation. And if you turn to the Serbia case to which we referred to yesterday, you will see that difference. For instance, at paragraph 432, the court says that the obligation not to aid and assist in the commission of genocide is a negative obligation. Okay, so that distinction is very, very basic. Actually, it is already reflected in Article 2 of the Articles on State Responsibility. When Article 2 says let me bring it to you. When Article 2 of the ILC, you know, the draft articles on state responsibility, when it says that there is an internationally wrongful act when the conduct consisting of an action or an omission, okay, the conduct is either an action or an omission. The conduct is an action or an omission. The violation of the obligation consists either of an action or an omission, because the obligation is either an obligation that is negative and the breach results from an action, or the obligation is positive and the breach results from an omission. Okay, that is very basic. Okay, and you have millions of obligations that are either labeled as positive obligations or negative obligations. Some people have doubt that the distinction makes sense. Some people have said, well, you may have a positive obligation hidden in a negative obligation, or vice versa. And it is true that when you look at certain rules will imply, okay, if they are a positive obligation, they will imply a negative obligation also, okay? But those nevertheless are different obligations. There is an interplay between positive and negative obligations stemming from the same rules. But those obligations are distinct nevertheless, because what consists of a breach of those obligations will either be an abstention, an omission, or a conduct, a positive conduct that you can see in the real world, okay? And despite this, and for instance, again, to take the Bosnia-Serbia case, in the Genocide Convention, there is no prohibition for the state not to commit genocide. There is no such rule in the treaty as such, okay? However, there is a rule that contains a positive obligation, which is the obligation to prevent genocide. And of course, if states have an obligation to prevent genocide, it is because they may not commit genocide themselves. And the court made that very clear. But the prohibition of genocide binding on states is constructed, is derived from the interpretation of the positive obligation. So there is an interaction between the two. Likewise, in human rights law, many positive obligations have been derived, some people say created by the judges, have been derived from negative obligations. And yesterday I mentioned the prohibition of torture, for instance, the protection of the right to life, and the prohibition of extrajudicial killing. Those rules that are labeled as negative obligations will also contain positive obligations, will be derived from those positive rules, from those negative rules. Negative obligations. In human rights law, the distinction between positive and negative obligations has also been criticized, contested, and people have suggested that the distinction should be replaced by a trilogy that you know very well, which is the distinction between the obligation to respect, to protect, and to fulfill human rights. And I think this, those verbs are very interesting because they encapsulate, they describe more precisely what is required from the state. But those verbs are not by themselves obligations. They are not. They simply describe what the state should endeavor to do, and they simply want to point at the fact that there is a continuum in human rights law from negative obligation the obligation to respect is usually considered as a negative obligation. To protect and to fulfill will reflect positive obligations of the state, including when the behavior of other individuals is at stake. There is an obligation to protect human rights from the interference of private actors, okay? And I think this is very useful analytically, but this does not replace the fundamental distinction between positive and negative obligations, in the sense that a breach of an obligation will always consist either of an action or an omission. So despite the criticism, I think, that has been addressed to the distinction between positive and negative obligations, I think you always fall back on that distinction when you have to assess whether a breach has been committed or not. Because in order to know if a breach exists or not, you have to know at what type of behavior you have to look at, whether the behavior is an omission or an action. So I think the distinction is pertinent. And by the way, the distinction is made in the case law of the ICJ, for instance, and in the case law of human rights courts. Okay, so I think it is inescapable that we always fall back on those basic differences. Now, what I would like to draw your attention to is that the distinction between positive and negative obligations has a bearing in the law of state responsibility, at least in regard of three important things. The first one being the question of attribution. You know that in the law of state responsibility, much has been said about attribution of conduct to the state. States are abstract entities, organizations also, they behave through human beings. And deciding whose conduct, the conduct of which human being, is attributable to the state is a very important matter. And we discussed yesterday the case again of Serbia and whether the conduct of the Bosnian Serbs is attributable to Serbia or not. And of course, rules on attribution are rules that somehow convey the understanding of what is a state, or also the understanding of what is an international organization. They relate to the subject, okay? And subjectivity, whose conduct is attributable to the abstract entity. Well, when you think about it, the distinction between positive and negative obligation is very important in terms of attribution. Because strictly speaking, when it comes to a negative obligation, you will indeed have to attribute, to impute a conduct in the real world that is by somebody to the state. And the rules of attribution have a lot of importance in that regard. There is the conduct of somebody, the conduct, the action, which allegedly is in breach of a negative obligation. And in that case, you will need to attribute that conduct through certain rules of international law, secondary rules of responsibility, to the state. When it comes to a positive obligation that is breached by an omission, a failure to act, actually, you will never apply rules of attribution as such. You will identify the state bearing the obligation, and you will simply see if there is an omission or not. But you will not as such attribute an omission. And if you look at the case law, that's very clear. If you look, for instance, at the hostage case, the case between the United States and Iran concerning the hijacking of the US embassy in Tehran at the time of the Iranian Revolution in 1979, 1980. Well, there is a failure to act, okay, on behalf of the authorities of Iran. They did not protect, as they should have protected, the premises of the embassy. There's a big debate in that case about whether the conduct of the students, the Islamic students that stormed and occupied the embassy, a big debate about whether that conduct, which is an action in violation eventually of a negative obligation, whether that conduct is attributable to Iran or not. But there's another obligation, which is an obligation to protect the diplomatic premises. And for that obligation, there is no discussion of attribution whatsoever. There is simply the court identifies the obligation, determines that the obligation is a positive obligation, that the breach of that obligation exists because Iran failed to do anything, okay? But strictly speaking, there is no attribution. There is just the identification of the obligation bearer, the state owing the positive obligation. So when you face a positive obligation in terms of litigation, the only thing that you have to demonstrate is that the state owing the obligation did not do what the obligation requires. But you don't have to do anything else. You identify the obligation and the state bearing the obligation, and that's it. You don't come into a debate about whether, if there is an obligation, if there is a positive obligation, there is somehow in international law a presumption that it is for the state to fulfill the obligation. Whoever is acting or not acting doesn't matter. Okay, the failure, whether it is the legislature, whether it is the government, whether it is a state organ or a person that is instructed by the state, it does not matter. There is a failure to act. Okay, and who was supposed to act never comes in the picture in terms of attribution. So. And when, as I said, sometimes the omission is only a partial omission. Yes, the state acted, but it didn't do enough to comply with the positive obligation. Well, in such a case, in a litigation, the state will claim the behavior as being its own behavior. Okay, the state will say, "Oh no, I fulfilled my obligation. Look at what I did." Okay, so the state is owing the attribution. The state, it's the debtor, the respondent state will say, well, this is my conduct and I did what I had to do. So there again, the attribution will not be controversial because the state will be claiming attribution for itself. What the claimant state will say is simply, well, maybe you did something, but you did not do enough. And there is still an omission, partial omission, that constitutes a breach of the positive obligation. So, of course, and when you read the work of the ILC on attribution, you will see that the Commission says that a state is responsible for actions or omissions, and omissions are attributable to a state. They are always attributable to a state, but you never discuss attribution of an omission. That it's nonsense. You just identify the duty bearer, and that's it. Okay, and that's why it is important to know if you are facing a positive or a negative obligations. It has a repercussion in terms of attribution. First. Second, the distinction is also important in terms of cessation of the breach, because when you are facing a negative obligation, cessation of the breach, if the breach is ongoing, requires simply putting an end to the wrongful conduct, okay? Which means that you have to stop doing what you are doing, okay? Cessation of the breach of a positive obligation is almost undistinguishable from the actual performance of the primary obligation. How do you seize the breach of a positive obligation? You seize that breach by complying with the obligation. And you have to perform. Because performing a positive obligation is action, okay? So you have to actually behave in the way required by the positive obligation. And that makes the cessation of the breach very similar, if not identical, to the performance of the obligation, okay? If the obligation is still binding, of course. While for a negative obligation, you have to stop doing what you do, which also is complying with the positive with the primary obligation. But there you can see in the real world that you simply stop doing something. Okay. Let me turn to the third issue, which is more tricky, and it's the issue of causality. Causality under the law is always controversial and is always a very legal matter. And you know that in international law, causality is probably more tricky than under domestic law because we have less cases and we have less practice. And but there is still the requirement that the injury results from the breach, okay? And that the obligation to make reparation is only triggered for the responsible state of the breach if the breach caused the injury, if from the breach the injury ensured. Now, when you look at negative obligations, those are obligations that are breached by a conduct in the real world that you can observe, okay? For instance, the prohibition on the use of force, to take a basic example, or for instance, the prohibition of torture, okay? If a state uses force, you can see that in the real world. If a state tortures a person, you can see that in the real world. And the assessment of causality will be rather straightforward, okay? You can see, materially speaking, something flowing from the breach. You can see a territory being invaded. You can see houses being destroyed. You can see a person suffering from injuries, physical injuries or mental injuries. So the causal link is fairly easy to establish, and to establish on the basis of, you know, the sine qua non test, the but-for test. Were it not for the breach, the injury would not have occurred. That's the basic, so elementary causal test, okay? But when you are dealing with a negative obligation, that appears very clear. If it were not for the invasion, the house would not have been destroyed. If it were not for the torture, the person would not suffer mental injury. That's very easy to establish. Sometimes it's more complicated because there is an issue of remoteness. There are in the causal chain, there may be numerous interactions, and we know that the case law has developed the requirement that the injury be direct, or that the injury be proximate, the proximate injury, or the requirement of proximity, or the foreseeability of the injury in the normal course of events. And those criteria are very important because causality under the law is not causality in the physical world. Okay, most of the time when we face negative obligations, it will be the same causality and causal assessment, but not necessarily so. And to take an example on the use of force, Both, for instance, in 1947 in the peace treaties with Italy, Hungary, Romania, and Bulgaria, or in the United Nations Compensation Commission that was established after the Iraq War of 1991, in both cases, you have a lot of case law that has been stretching the causal link from the illegal aggression to the injury, but including to the injury that has materially resulted from the military action of the Allied powers. Okay? So a bomb falls from an American airplane. That airplane destroys a military objective on the ground. Materially speaking, it comes from the action of the American forces. However, from a legal point of view, the reasoning is such that without the Iraqi invasion of Kuwait, the Americans would not have engaged in a war authorized by the Security Council. Therefore, it was foreseeable that if Iraq did not withdraw from Kuwait, a military action would result. And it was foreseeable for Iraq that the United States would use military power. Okay, so this is causality in legal terms. Okay, you stretch the causal link from the breach, from the initial breach, and you cover with causality the behavior. You attribute, not in terms of conduct, but in terms of causality, you attribute an injury to Iraq, while the injury, physically speaking, was not the result of Iraqi action, but of the action of the Allied powers. Okay, so that's why causality under the law is very different from causality in the real world. But when you face negative obligations, it usually is fairly straightforward, okay? Because you can see things in the real world. When you face positive obligations, obligations that are breached by an omission, then when you apply the sine qua non test, when you apply the but-for test, things become extremely hypothetical. You have to imagine, to establish causality, and this is what the court required, the ICJ said in the Bosnia case, you have to imagine the situation that would have resulted if the state had complied with the obligation. So you have to imagine something that never occurred in order to assess whether the injury that occurred would not have existed. So it's very, it's amazing what we have to do under the law. We have to imagine a past that never existed, imagining whether the present would have changed. Okay, and it's very difficult. It's a hypothetical counterfactual that is very difficult to match. And at the end of the day, it will be a human judgment. And at the end of the day, somehow, it amounts to how much do you think that the positive obligation is capable of changing the real world? Okay, that's at the end of the day, that's what the judge will have to assess. Okay, oh, there is an omission. Had the state done, if the state had done what it had to do, would the world have been different? Which means, is the positive obligation so much commanding on reality? Okay, is it so much a tool for a change in the real world, or is the real world so complex that other elements, you know, would in any case have led to the same outcome? And that's what the court had to assess in the Bosnia-Serbia case. Okay, had Serbia behaved properly in preventing the genocide? Had Serbia done everything it could have done, would the injury still exist or not? Okay. And the court said, I'm not 100% sure. Maybe if Serbia could have done more and complied with its obligation, the genocide would nevertheless have existed. Therefore, there is no causal link. Okay. So it's a pure mental assessment. There is nothing in terms of material causality, nothing at all. It's a judgment on what and how the world could have been if what did not happen would have happened. Okay, so it's extremely abstract. But again, the level of abstraction when we face the breach of a positive obligation is much higher than when we face the breach of a negative obligation. And I submit that very often when people analyze causality, they, under international law, they fail to make that distinction between positive and negative obligation, and they fail to understand that the but-for test in a positive obligation context amounts to a very hypothetical counterfactual. Okay, and therefore maybe we should be thinking about another test, another causal test when it comes to positive obligations. But so far the case law is very is very limited, and it's very difficult to determine. Now, let me turn, I see that the time is flying. Let me turn to the distinction between obligations of result and obligation of conduct. Yesterday, there was a question put to me, an interesting question by a student, I'm sorry, I don't remember her name, saying, well, if a state has the obligation not to interfere in the foreign, in the domestic affairs of another state, and because I said they cannot be, in my opinion, a negative obligation of conduct. In my opinion, that does not exist. Okay, you remember the table I made when yesterday when I shared my notes, I showed you that in my opinion, you cannot have a bilateral, you cannot have an obligation or a negative obligation that is a negative, that is an obligation of conduct. Okay, you remember that? Let me share that again to you. And she said, well, isn't that a negative obligation of conduct? The obligation not to interfere in the domestic affairs of another state. Well, I submit that this is not an obligation of conduct. It's an obligation of result. Okay. Of course, it's an obligation that requires a certain conduct, but the distinction between obligation of result and obligation of conduct means something else. And this is what I want to bring to you this morning. What is this distinction? The distinction comes from the French legal system that exists in Roman law or in other Roman law systems. It's the distinction between l'obligation de moyens et l'obligation de résultat. Obligation of means, if you want, obligation of conduct, or obligation of result. An obligation of result is an obligation to succeed. It's a very strict obligation. You have to reach a certain outcome. You have to be, in each time you have to behave, okay? There's a conduct each time. But you have to succeed in achieving a certain result. For instance, you have to succeed in not using force, or you have to succeed in, you may have positive obligations of result, okay? And the obligation is breached by not attaining the expected outcome. The state will usually be free to choose the means that it wants to choose in order to achieve the result. But the result it must achieve. And that's an obligation of result. An obligation of conduct, in contrast, is an obligation to do the best you can. Not necessarily, not necessarily achieving the result, but at least doing the best you can to comply with the obligation. The obligation of conduct is a positive obligation to try, an obligation to endeavor, and it's breached by the failure to act with due diligence. Okay, and the distinction is important because obligations of result are strict obligations. The obligation is breached because the result is not achieved. When you have to prove the breach of an obligation of result, the claimant has an easy task. The result is not achieved. When you have to, for instance, the prohibition on the use of force, I'm sorry to fall back on that. It's not simply, I did my best not to attack my neighbor. No, that will not be a good legal excuse. Okay, you should not, attack your neighbor, full stop. And the result is expected from you. The result being a world where war does not occur. When we face an obligation of conduct, the burden of proof on the claimant will be more difficult. The claimant will have to prove that either the respondent did not do anything, because it's a positive obligation of conduct. It's always positive obligation. So if you didn't do anything, that's easy. There is a complete failure to act. But if there's a partial omission, you will have to show that what was done was not enough. And the question will be, what is the enough? What should have been done? And the obligation of conduct will be an obligation that will vary over time. What you can do in 1920 is not the same as what you can do in 2020. Because knowledge has improved, for instance, because the capacity to act has improved. The same obligation will change over time. What is required to comply with the obligation will over time be evolving. And that's why obligations of conduct are very useful in terms of negotiating a treaty, because you know that this obligation will, the due diligence obligation will evolve over time. There's a debate to know whether due diligence evolves and is different from state to state, whether you're a developing state, you don't have the same means as a rich nation. And my understanding of obligations of conduct is that indeed obligations of conduct, because they're required to do what is reasonably possible for the state to do, due diligence, this will vary in time, but in space also. What the United States can do is not the same as what Burkina Faso can do. And certain obligations of conduct, of course, will have to be assessed differently in light of the various duty bearer. So it's an instrument that it's a type of obligation that gives in international law a certain flexibility, and therefore also increases debates, claims, contradictory claims of states. But it's a distinction that exists in positive law, and if you look at the case law of the ICJ, again you will see the distinction between obligations of result, obligations of conduct. In the International Tribunal for the Law of the Sea, you will see the two advisory opinions of 2011 and 2015, where the ITLOS Tribunal also refers to obligations of conduct and obligations of result, and characterizes certain obligations as being obligations of conduct rather than obligations of result. And the distinction between the two, what makes an obligation of result or an obligation of conduct, is a matter of interpretation, but of the rule containing the obligation again. But the main reason for distinguishing is the issue of risk. Is there a risk? And is the duty bearer facing any risk? And the risk may result from nature, because states cannot control everything, because natural processes exist, or the risk results from the conduct of individuals. Okay, for instance, in investment law, the obligation of full protection and security that the state owes to the investor. Well, full protection and security is to a certain extent an obligation of conduct. The state must do everything it can to physically protect the investment, like for an embassy, okay? It's an obligation of conduct. There are some situations in which a mob, a crowd, will be overtaking the protection of the state. Even if the state did all it could, posted soldiers and policemen, that was not enough, okay? And the state may have complied with its obligation of conduct, and nevertheless, the embassy would have been invaded by the crowd, okay? And the risk exists because the behavior of third parties are at stake. Behavior that is not attributable to the state itself. So there was yesterday a question also about soft law. And I think here I'd like to take that question and to illustrate in relation to illustrate soft law and the role played by soft law in relation to obligations of conduct. If we take the pulp mills case between Argentina and Uruguay, you remember it was about the construction by Uruguay of pulp mills along the river, that is the border between the two states. In that case, in order to determine whether Uruguay complied with its obligation not to pollute the Uruguay River, which the court will determine to be an obligation of conduct, one question arose about the construction of the pulp mills. And because Uruguay has an obligation to do all it can to prevent the pollution, Uruguay has the obligation to use the best available technology and to require from the pulp mills that they use the best available technology in the process of producing pulp pulp for the production of paper. So there is an obligation of conduct, says the court, but in order to assess whether the obligation of conduct is complied with or not, the benchmark that will be used to know whether Uruguay acted with due diligence, the benchmark that will be used will refer to soft law. And the soft law in this case being a document issued by the European Commission. Okay, so between Argentina and Uruguay, you will refer to a European Union document about the best available technology for the production of pulp mills. Of course, that document is not binding on Argentina and Uruguay. It's not even binding in EU law. It's just a standard, an industrial standard of production for pulp mills. And it is the best available technology. Today, at the time, maybe in 50 years, it will be a very polluting or considered to be very bad and polluting technology. But today, it is the best available technology. So in order to assess whether Uruguay complied with its due diligence obligation of conduct, the court will see if the best available technology was used by Uruguay in the pulp mills. And this is done by referring to a soft law instrument, but an instrument that will have a great importance, of course, because where do you, due diligence means doing everything you can, reasonably everything you can. What does that mean concretely in terms of industrial standards? In order to do that, to know what it means, you look at the industry, the best available technology at the time, okay? And that is the interplay between a positive obligation under the Uruguay Treaty, Uruguay River Treaty, that's a 1975 treaty, which the court characterizes as an obligation of due diligence, an obligation of conduct. And in order to give concreteness to that obligation, the court will use a soft law instrument, okay? Not transforming the soft law instrument into hard law, okay? Because the hard law is only the obligation under the treaty, but to give concreteness to that treaty obligation. What was good for the court in that case was that both Argentina and Uruguay agreed between themselves that the European Union document was the good reference, okay? The question, and therefore for the court it was easy using that document. The question you can ask yourself is, what would have happened if the two countries were not in agreement about using that soft law instrument? What should have done? What would the court? How should the court have reasoned the case? And my submission is that the court should have, also have to look around at the best available technology, interpreting the due diligence obligation to the fullest, and requesting from Uruguay to comply, not with, a lower standard, but to comply with the best available technology at the time. And the court, I think, would have had to do the same. And the best available technology was this technology used in the European Union, and specifically in Finland, where a lot of pulp mills are being produced. So this interplay between soft law and hard law is very interesting when it comes, and very much at play when we talk about obligations of conduct, okay? But again, we have to be careful not transforming the soft law into hard law, okay? There's a bridge between the two because the due diligence criteria for the obligation of conduct, for the performance of the obligation of conduct. Now, a subcategory, and I will finish here before taking your questions, a subcategory of obligations of conduct are obligations of prevention. The obligation to prevent is a specific type of obligation of conduct. It's an obligation of conduct because it is also a due diligence obligation. It's also an obligation that must be performed by doing the best you can, but not necessarily by achieving the result. As the court said in the Bosnia case, of course, the obligation to prevent is triggered before the event to be, before the occurrence of the event to be prevented. But that obligation is only breached if the event to be prevented occurs. Okay, so it's a tricky obligation. It's an obligation that is triggered prior to the event, of course, because you have to prevent it. Okay, but it's an obligation that requires to do all you can to prevent the occurrence of an event. But it is only if the event occurs that you will be able to know whether the prevention duty has been breached or not. Okay. And it is no excuse to pretend that the event would have occurred anyway, even if you did everything you could have done. Okay. So it's a very tricky obligation. And let me refer you to paragraph 430 of the 2007 judgment of the ICJ in the Bosnia-Serbia case. So I see it's already 1 hour that I've been lecturing. Again, it's very intense. I'm sorry, it's very abstract to a certain degree. But let me bring back this table of combination. We have to look at obligations in terms of combining those dimensions, those modalities. The obligation might be bilateral or collective, and if it is bilateral, it can be a negative obligation of result or a positive obligation of result or a positive obligation of conduct, and likewise for collective obligations. And again, to a certain degree, I fully agree that those modalities or this typology is very abstract and very how to say, does not make justice to the full diversity of obligations. Okay, there is an immense diversity of obligations. All obligations are different. However, and to come back to the essential, however, all obligations will, at the end of the day, you will be able to discern the most important elements of those obligations through that typology. And I think the typology is performing, in the sense that the typology helps us to interpret rules, to find obligation, and also the typology helps us to better identify the legal regime, notably in terms of responsibility, the legal regime flowing from the breach of an obligation. So that's what I wanted to convey to you today. Thank you very much for your attention yesterday and today. And of course, I'm in your hands for questions that you may have. Thank you.
Thank you, Professor. It was again fantastic. We have questions here. We'll begin with the question of Rodrigo Franco. He asks, Professor, would you say that the obligation of non-recognition as presented in the RCWA is part of customary law? And which is the nature of such obligation? In your typology, do you think it is possible to regard an obligation of non-recognition in Palestine versus USA, ICJ 2018? Due to its general nature, even though there is no mention about in the Palestinian petition. I think that's the first one. We have another 4 that can be combined. Do you think it's better do all together, or this first one and then?
Let me take this first one then. Let me take the first one. Okay.
Okay.
As to the obligation of non-recognition, as understood under RCWA, it's an obligation, it's a secondary obligation that flows from grave breaches of peremptory norms. it is, I think, indeed a customary law obligation. It is not an obligation. I mean, it can be imposed by the United Nations Security Council, and we have seen in the practice that the UN Security Council has imposed such obligation not to recognize. For instance, if we take the Turkish Republic of Northern Cyprus, or if we take the Republika Srpska of the Bosnian Serbs, there you will find a clear obligation binding on all member states not to recognize. Otherwise, I think the ICJ has said that both in the 1971 advisory opinion on Namibia and on the continued presence of South Africa in the Southwest Africa, or in the Wall advisory opinion, that the duty of non-recognition exists under general international law, that is customary international law. I would characterize that obligation as a collective obligation which is a negative obligation of result. Because it's a collective obligation, because I think the interest in requiring compliance with the obligation lies in all states. All states are bound by such obligation, and all states have a legal interest in requiring compliance. So, for instance, if a state recognizes the Turkish Republic of Northern Cyprus, it is not only Cyprus that has interest in contesting that behavior, it's all states, because of the peremptory nature of the rule that has been breached. First, it's a collective obligation, I would submit. Second, it is a negative obligation. It is obligation not to recognize as legal. And so states have a duty to abstain from recognizing. I don't think that states have a positive obligation to do something or to contest. They simply have an obligation not to recognize. And it's an obligation of result in the sense that, you know, something is expected from them. And what is expected is simply not to recognize. It's not a best endeavor obligation. It's not a due diligence obligation. So that is for the how to, you know, apply my typology to that specific obligation, which is interesting, by the way, because it shows that the typology also applies to secondary obligations in international law. It does not only govern the understanding of primary norms, primary obligations, but it also applies to secondary obligations. Now, to come to the case that was brought by Palestine against the United States, I'm not involved in that case. I think it's an interesting case. However, I see one issue in that case, which is the fact that the case is brought under the 1961 Vienna Convention on Diplomatic Relations. There are no diplomatic relations between Palestine and the United States. The instrument under which the dispute is brought is an instrument that is supposed to regulate obligations between states that have diplomatic obligations. Now, it might be the case that some of the obligations that Palestine claims that the United States has breached, it might be the case that some of those obligations under the Vienna Convention either are customary international law obligations also, but in any case are obligations that apply irrespective of the existence of diplomatic relations. This being said, when you look and simply the title of the 1961 Vienna Convention, it is the Vienna Convention on Diplomatic Relations between States. So there's an issue of, you know, is the instrument applicable in the relation between the US and Palestine? Full stop. Okay. And I'm not sure of that. I guess it's an issue that the court will have to address. I'm sure that the United States will raise the issue. Of course, you know, it's a very delicate dispute, and it might be a way out for the court. However, the dispute is not premised. I don't remember precisely. I've read at the time. I have read the application from Palestine, but I'm not sure that the dispute is premised on the violation of the obligation not to recognize. I don't remember that precisely. So the other obligations have allegedly been breached by the United States, but I don't remember that Palestine makes. But I may be wrong on that. I'm sorry, it escapes my memory. But that's what I would say for that first question. Thank you.
Thank you, Professor. The second round, we have questions about environmental law from Jean Ferreira and Bruno de Souza. Could you please talk about soft law and principles as the main source of international environmental law? I think you already talk about soft law, but they want to talk about international environmental law and soft law.
Yeah, I'm happy to do that with the caveat that I'm not a specialist of environmental law at all. Well, at all, even if I've been involved in environmental law cases. I think, of course, you know, I mean, the classification of an instrument as being soft law very much depends on what you take as being your theory of the sources of international law. Okay, we go back to that. I am a fairly classical international law lawyer, so I am, in that regard, you know, very orthodox, and I am fairly conservative in the sense that I would classify certain instruments as not falling within the theory of sources. It doesn't mean that they are not important and relevant. They are, of course, they are important and relevant. States sometimes spend month and month and month of negotiating instruments that pretend not to reflect or not to bind them, okay? Sometimes those instruments will nevertheless reflect certain existing obligations. They will contain, you know, obligations, but obligations that exist under general international law, customary international law rules. And in soft law instruments, you will find a reference to some of those rules. Now, the instrument as such will not be binding, but it refers to an obligation that is binding under a usual process of lawmaking under international law. And other parts, and the difficulty will be to distinguish within the soft law instrument what is really law or what is really a repetition of law and what is not, and what is an incentive to move forward. I think we must remain always extremely careful when we say, oh, this is law and this is hard law. I mean, this is an assessment that is extremely important, and we must make sure that what we say is correct, because we don't want, we want states to continue, you know, it's important that they sign soft law instruments. It makes them move forward, okay? So we don't want to discourage states from doing so, from inventing, you know, soft law instruments that allow them to have some guidelines, you know, that it gives them a certain horizon. It's not binding, but it's not really important that it is binding. It's a political way forward. And if we trap states by saying, oh, this is binding on you, well, next time they will do nothing. And we don't want to end up in such a situation. So, and that is why I think it is important to be prudent. Some people will say conservative, to be prudent when assessing the bindingness of those instruments. but they are, of course, important, and I think they are most useful when they interplay with obligations of conduct, as illustrated in the Pulp Mills case. That is a very interesting, I think, and probably most illuminating interplay between hard law and soft law that you can imagine. So that's why it's important to keep the flow of soft law occurring. And in order to keep the flow of soft law occurring, we really have to treat it for what it is and not for what it is not. That's what. But in environmental law, soft law has historically played a role precisely because states. I mean, we face a field where the interaction between the behavior of private actors and the behavior of states, between human behavior, globally speaking, and natural events, is such that there's a lot of, reluctance to bind yourself strictly. Okay. But nevertheless, there is a social need to regulate or to approach common problems with common lenses and analytical tools, and that's why soft law has been so much developed, I think, historically speaking, in environmental law, and it has, I think, over the years produced some hard law results. Yeah, certainly. That would be my answer.
So now, human rights. Marina Maha asks about how can human rights law and positive obligation help with the protection of healthcare personnel and vulnerable patients in the COVID-19 pandemic? And she also asks about the Max Schrems. I really don't know how to pronunciate the surname of Max correctly, but why did the judgment of the European Court of Justice in the case of Schrems established that the European Commission needed to adopt a more active approach in examining whether a third country, such as USA, provides for an inadequate level of protection if it was the USA who breached the positive obligation? Those questions are from Marina Maha.
Okay. On the second question first, on the Schrems case of the European Court of Justice, it's a recent case. I'm not sure everybody is aware of it. I have not read the case yet. I've heard about the case in newspapers, but I have not read the case. It's a judgment that relates to the protection of privacy and private data of European citizens that is shared with the United States under certain agreements in terms, when you take a plane to the US and things like that. I don't know the details of the case. Okay, so I'm not going to comment on the details of the case. But one thing I can say is that the reason why the European Court of Justice has quashed European law instruments, and including instruments that give effect to treaties concluded with the United States, is because the European Court of Justice has the authority to annul, invalidate European Union acts if they do not conform with the Charter on Fundamental Rights. And so the European Union legal order stems from international law because it's based on treaties. But at the same time, as the European Court of Justice has said time and time again, it is autonomous from international law. It establishes itself as a separate legal order, and it defines by itself how it interplays with international law in a very similar way to the way that domestic legal systems interact with international law. It is for each domestic legal system to determine to what extent international law applies internally, okay? And for international law, it doesn't make any difference. I mean, you breach your obligations, but there is in every state a certain degree of dualism between domestic law and international law. The same is true for European Union legal order. European law is separate from international law, and the conformity of European Union Act with the basic treaties and the Charter of Fundamental Rights is a matter of hierarchy of norms within the European Union legal system. So, and of course, the European Court of Justice has no power of adjudication vis-à-vis the United States of America or any other country, other third country. Of course not. It's a domestic court. It's an internal court of the European Union. But again, the details of the Schrems case, I could not comment. But it is quite usual for the European Union, for the European Court of Justice to quash decisions or acts of the European Union. It's a classical, constitutional court that looks at the validity of certain acts in light of superior norms, and those norms being the fundamental treaties on the European Union and the Charter on fundamental rights, which have some constitutional value, if you want, in the European Union. On COVID-19 and human rights, I'm really at a loss because I'm not sure I understood the question, and I'm not sure I could really comment on human rights aspects. There is certainly some human rights issues involved. The right to health, of course, is at stake in this debate, and in the typology between obligations to respect, to protect, or to fulfill. It certainly is a positive obligation of the state. I don't think that we could characterize the right to health as an obligation of result. And by the way, in domestic law, this distinction between obligation de moyen, obligation de résultat, obligation of conduct, obligation of result, stems from medical practice. In French law, a doctor has no obligation to cure you. Doctor only has the obligation to, be a good doctor and do everything he or she can to bring back good health. But good health is such a there is so much at stake, so many different elements intervening, and medical science is not a perfect science, that the outcome is always uncertain in certain regard. Now, you could say, and the domestic case law in every country has evolved. Okay, some very mundane medical treatment can be considered today as an obligation of result. Okay, some basic mundane things, that very routine stuff that every doctor should perform properly. But for the rest, it's not an obligation of result. It's an obligation of conduct. And I would say that the human rights obligation of the state to provide its citizens with the best possible health care, or to protect the health of its citizens, is an obligation of conduct. This being said, we fall back on the issue of, did the state do everything it could, in its own power, to actually indeed protect the health of its citizens. And there might be some failures, okay? There might have been some reluctance, there might have been obvious omissions, okay? Failure to act. And it's not because it's an obligation of conduct that it's a meaningless obligation. On the contrary. But to pretend that the state must make sure that none of its citizens is going to die would be stupid. Okay, this is certainly not the case. And government would stop. You know, if that is what is required by the law, then nobody wants to engage in any sort of politics anyway, because you will fail. Of course, there will be. But anyway, and if you think about it, it's probably in terms of social contract, when you fall back on the philosophy behind all that, saying that it's a due diligence obligation is something very strong. It means that the state has positive obligations to do everything it can, and and to engage with the protection of the health of its own citizens. But honestly, I'm sure that there must be some. I think there is a UN special rapporteur on the right to health. I'm sure that person will have a lot to say about the COVID-19 crisis. And it will be interesting to read the reports and to read from the reports how the special rapporteur understands the obligation to protect the health of citizens and the right to health. That's what I would say.
Thank you, Professor. Now we have one from Amanda Lemos. She asks, in the Nicaragua case, the ICJ applied the effective control test for attribution, positioning itself against the overall control test applied by the ICTY in the Tadic case. Would you say the court was correct in applying a more strict test, or still did not dive in establishing proper attribution itself? And there's one more from Talia Paceto. The distinction between interdependent and integral collective obligations can only be determined if the norm expresses the legit response to the breach of the obligation, or it can be determined even if the norm is silent about that. So that's the two last questions.
Yeah. Okay. Thank you very much. The Nicaragua case, yes, I mean it's a classical instance of fragmentation of international law, where we have one court applying a certain rule for attribution, the ICTY with the overall control test, and the ICJ applying the effective control test. By the way, the court in the Nicaragua case in 1986 developed the effective control test, and later came the Tadic case of the ICTY, but then in 2005 and again in 2007, and very specifically in 2007 in the Bosnia-Serbia case, but already in a way in the Uganda case, DRC Uganda case, the effective control test was reaffirmed by the court. So it's really a matter of who do you consider as the authority, the ultimate authority to assess rules of customary international law. Is it the ICTY or is it the ICJ? I think, I mean, the case law, I think, is settled. It is effective control, and there's no going back from it. We have to accept the ICJ finding for what it stands. It has been repeated, it has been criticized, and the court fell back. I think it very much reflects the idea that states are responsible for what they do, okay, for what effectively they do. So it's also, I think, a criteria which suits states very well. Okay, I fully understand the criticism that is addressed to the effective control, because the burden of proof that results from such attribution criteria is nearly impossible to meet. Okay, how can you, and most of the time those are covert operation, those operations where a state, gives weapons, or gives finance to groups, etc., etc. So it's a criteria that somehow allows states to do their dirty business easily and getting away from it, with it. Okay, they do their dirty business and they get away with it easily. At the same time, it's a criteria that prevents the making of certain arguments that would be extremely destructive of the world. Look, for instance, at if it was the overall control test, you would unquestionably be able to say to Iran, you are responsible, Iran, you are responsible for what the Hamas is doing or what the Hezbollah is doing in all parts of the world. The aggression by Hezbollah is the aggression by Iran. So I am Israel, I'm going to bomb you, I am the United States, I'm going to bomb you. So in terms of self-defense, the overall control test would have catastrophic results, because it will allow immediately to consider that you are under the law of self-defense, under Article 51 of the UN Charter. It would allow you to say this is the aggression of that state. It is the conduct of a group, that the group is controlled by the state, and therefore it's attributable to the state, and therefore I can go and bomb. So in a way, the overall control test is in today's international community, at the same time, something that would allow of course, to find states responsible for their dirty business, but at the same time, it could very well result in catastrophic outcomes, because it would give some very powerful actors even more power to display the use of force around the world. So we have to, when we criticize the ICJ for what it did, we have also to understand all the facets of the rule. That's what I would say. Now, on interdependent integral obligations, I think you do not need the norm to be explicit. Those are doctrinal categories. You will not find in a treaty saying, hey, by the way, this is an integral obligation, or hey, by the way, this is an interdependent obligation. It stems from the system of the treaty, from the regime in which the rule is embedded. It's, I think, a matter of interpretation, and it really is on the it is for the interpreter, including the states parties to the instrument, and sometimes it will be very obvious, okay, that this is a rule, this is an obligation that is of an independent character or an integral character. When it relates to human rights instruments, for instance, of course, those are integral obligations. They must be obeyed. They must be complied with, irrespective of whether the other side complies or not. And vice versa for interdependent obligation. When it makes no sense for you to continue performing your obligation, if the other side does not perform, you can stop performing vis-a-vis all other states, parties to the instrument. So it will be a matter of interpretation, for sure. And sometimes it might be a matter of evolution. For instance, take the Whaling Convention. The Whaling Convention, is that an integral obligation or is that an interdependent obligation? It really depends on if you consider that whales are something very special in nature that needs to be protected. But you may say, you know, if it's an interdependent obligation, well, Japan is fishing, I'm going to kill whales also. Okay, if they don't do their part, I'm not doing my part, which is very bad for the whales. So you might, but there's some logic. There is some logic in it. So you might end up saying it's an integral obligation, which you know, very much depends on what value do you assign to the object of the treaty. And that is what is interesting with the classification. It's because it brings us back to, you know, assessment of values. What do we consider as being important and how important it is, in which way it is important. So this classification triggers all those type of questions, which are very often silenced by the rules, okay? And it's for the interpreter to make them clear and to give weight to the obligation. So that's my answer.
Thank you, Professor.
I saw that it's already 8 minutes.
No, don't worry. It's so wonderful. I think it was wonderful for the students too. It was for me. I'd like to thank you again. And hope we will see each other in the future, presently or remotely. Thank you.
Thank you very much for your kind words. It was a pleasure, ladies and gentlemen, to address you yesterday and today. And thank you very much, Luis, for your kind words. I was very pleased to meet you also, and I'm sure we'll meet again. Thank you very much.
Thank you. Bye-bye.
Bye.
4, yeah, 5, 6, 7, 8, 9, 10. Let's go. Good morning, dear colleagues and students. We will begin the second part of Professor Bruno Zima conference on the International Court of Justice and Human Rights. After the lecture, I remind everyone that we will have 20 minutes for the questions that you can post in our chat room. Again, I thank a lot Professor Bruno Zima for his participation in our CEDIN International Law course, and I give him the floor. Professor Zima, the floor is yours.
Thank you very much. Dear audience, I hope you had a good evening and a good night and can stand me for another let's say, hour or so. You will remember that yesterday I started describing the most important human rights cases, or you could say the cluster of human rights cases that were decided by the court since 2010, since 2010. And I started with the Diallo case between Guinea and the Democratic Republic of Congo. And then I mentioned a case that I liked less, but which of course is a human rights case, which is the case between Georgia and Russia on the application of the International Convention on the Elimination of Racial Discrimination, which at the end founded when the court did not find that the jurisdiction was given. So that case did not come to an end on the merits. Now, after this negative, let's say, a milestone, we come to a case which is to be seen in a very positive light. I think it is the first of two cases that are almost too good to be true, against the background of what the ICJ had decided before. And that is a case brought by Belgium against Senegal in 2009. Belgium sued the Senegal on the following basis. There is the African state of Chad, and in that state, a dictator, Habré, had reigned for a decade of years and killed and tortured political opponents, etc. Now, Habré was removed, and he went to Senegal and lived a relatively comfortable life there. Now, both Belgium and Senegal are states members of one of the big UN human rights conventions, namely the UN Convention Against Torture. And this convention contains an obligation according to which every member state has to prosecute or punish persons who are considered or to have committed tortures or other inhumane treatments to people. Now, Senegal did not really take any steps against Habré, and so Belgium came on the fore. The question is, why Belgium? I think Belgium, that we remember that we are going to see from another case, has a special judicial institution, which is the figure of the juge d'instruction, which is mainly essentially young people, very eager. And one of these juges d'instruction in Belgium issued an international arrest warrant against Habré. And Belgium had to take this up. There was political pressure. Actually, some political refugees from Chad had gone to Belgium, had in the meantime become Belgian nationals, and had also kind of made their influence. So the Belgian government really went to the ICJ and said, well, Senegal, you are violating, you're neglecting your obligations under the Torture Convention. You have to either start your own prosecution, or you have to extradite and have you surrender the person to another state party to the Torture Convention, which is able and willing to prosecute that person. And then they said, if you don't do it yourself, you have to deliver Habré to us, to Belgium. And nothing happened, nothing very much happened. And so things went to the ICJ. And the interesting thing here is, what is the legitimation, what is the standing of a state like Belgium in a case like that? And this was the first occasion in which Belgium relied on something that the International Law Commission had devised about 10 years before, when they dealt with the topic of state responsibility. The articles adopted by the International Law Commission on State Responsibility have a chapter on invocation of responsibility. And there is a novelty there. According to the law designed by the International Law Commission, state responsibility, that is the invocation that another state has breached a rule of international law and is therefore responsible, such invocation can not only happen by states that have been directly injured, but also by what the Commission calls states other than injured states. Belgium put forward the case basing itself on both of these positions. They said, we are, first of all, a state party to the Torture Convention, like Senegal, and every state party to the Torture Convention is entitled to bring a breach to the ICJ. They also invoked their quality as a state other than, as an injured state, because they said, we have asked you to obey with your obligations under the Torture Convention. We have been in diplomatic intercourse that you have not reacted, you have not sufficiently reacted, and therefore we also can consider ourselves to be injured. The International Court decided the case in 2011 and said, yes, indeed, the Torture Convention is a treaty which contains obligations erga omnes partes. You will remember from yesterday, Barcelona Traction, obligations erga omnes, that is obligations, breach of very important norms of international law, like the obligation not to commit genocide, obligations in the human rights field. And these obligations create an entitlement in all other states to invoke the responsibility of the state which is in breach. So, and this invocation, this construction was used for the first time before the ICJ by Belgium against Senegal. And the ICJ took it up and it accepted it. Let me just say in square brackets that both the Russian judge and the Chinese judge were very critical of that construction, but the great majority accepted it. So the court found that indeed the Senegal had violated its obligations under the Torture Convention by not engaging in prosecution of Mr. Habré. And the court also found that the prohibition of torture was a rule or an obligation which was anchored in customary international law. So a very important finding on the sources of human rights law. It cannot only be treaties, it can only be customary international law. That is the Belgium-Senegal case. At the moment, at current, the International Court of Justice is dealing with another case which is similar to that, which is the case brought by Gambia, the African state Gambia, against Myanmar. In Myanmar, you probably have heard about that there were grave violations of human rights, mass atrocities committed by, alleged mass atrocities committed by the Myanmar armed forces against an ethnic group which lives in the most western part of Myanmar, the so-called Rohingya, which led also to mass exodus of people into the neighboring country, Bangladesh. The case or the situation also has a religious background. The majority population of Myanmar is Buddhist, whereas the Rohingya are a Muslim minority. There were UN investigation missions which came out with very, very, let's say, terrible reports about what had happened, etc. There is an international organization, the Organization of Islamic Countries, the OIC. And the OIC got together and the state of Gambia took the lead. Very interesting, because until very recently, Gambia was under a dictatorship with a lot of human rights violations happening. But this dictatorial regime had been removed and the new government was a liberal government and very human rights friendly, and especially the Attorney General and ministers, etc., of Gambia took a keen interest and were very concerned about what happened in Myanmar. And so Gambia went to the International Court and claimed that by the Myanmar called clearance operations, Myanmar committed acts of genocide. So it's another genocide case. But different from the genocide cases, Bosnia against Serbia, Croatia against Serbia, this case was not brought by a state deeply involved or the victim of the genocide, like the Bosniaks in Bosnia-Herzegovina, the Croats, but by a state where again the question arises: what is the entitlement? What makes Gambia a state legitimately claiming the commission of genocide by another state? And again, the same construction is at the basis of that claim, that the modern law of state responsibility entails the possibility for a state other than an injured state to invoke the responsibility of a wrongdoer for breaches of obligations which are erga omnes, universally, or erga omnes partes, partes standing for parts or parties, that is, states that are parties to one and the same treaty. A few months ago, the International Court of Justice rendered a provisional measures order which obligates Myanmar to desist from these human rights violations, from violations of international humanitarian law, and which obligates Myanmar to make periodic reports to the court indicating what steps they have taken to prevent these acts from being committed. These measures were adopted unanimously, which is really a remarkable achievement. Now, of course, the case enters the stage of the finding or the decision on jurisdiction, and Myanmar will certainly fight against jurisdiction by the court by all means. My prognosis is that the court will find that it does have jurisdiction on the basis of the Genocide Convention, because if you look at the Genocide Convention, it's quite clear. Every member state of the convention is entitled to bring a case to the ICJ if there is if there is a dispute. The dispute is there between Gambia and Myanmar because Gambia engaged in diplomatic exchanges with Myanmar about the matter. That was sufficient for the court to find that there is a dispute between the two countries, and there is a legal standing on the part of Gambia. But of course, the decisive question will be, okay, once jurisdiction is accepted, we reach the stage of the merits, and what is the court going to find about the merits? And that is a very, 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 very big benchmark to pass, because I think, as I mentioned yesterday, and I'll mention that today, the pattern of, let's say, mere state behavior, patterns of state behavior as such cannot establish or the commission of genocide. What is necessary for the court to find a commission of genocide is that these acts, whatever mass violations, massacres, ethnic cleansing, that these acts are done with a special intent, a dolus specialis, and that the special intent is the more or less the annihilation of a group, the extinction of a group. Now, you will remember in the genocide cases concerning the Balkan wars, the court came to the conclusion that with the exception of Srebrenica, all the other violence that happened there, and the entire violence committed by Serb troops against Croats, did not amount to genocide. They were crimes against humanity. And the aim, the purpose of these violations was to shock, to deter the population on the ground and make the population flee to a neighboring country. And of course, that is, according to the ICJ, that is not genocide. It's ethnic cleansing, but ethnic cleansing alone is not genocide. And so if you really ask me what is the outcome that I expect from in the Gambia-Myanmar case, I would say, unfortunately, I think the court will not be able to find that special intent. There is one element which makes things even more difficult for the ICJ in the present case than in the Yugoslav cases, and that is the non-existence of an international criminal tribunal. Of course, this international criminal tribunal was there in case of the war in Yugoslavia, and of course, this international criminal tribunal had the prosecutor's office in that tribunal had engaged in massive fact-finding, and so the ICJ was able to base its own findings on what the ICTY, about 1 kilometer away from the ICJ, from the Peace Palace, had found in that regard. In case of Myanmar, no such international criminal tribunal is underway. There is at the moment, there is no claim or no project to create such a tribunal. And as I said yesterday, the ICJ is more or less not capable to engage in its own independent fact-finding. So what they can do is can rely on UN observer missions, on UN investigations, which of course a reliance on such third-party observations, etc., is very problematic as a method of proving a certain activity. So I would love to lose the bet, but I think that the court will not lead to a finding of genocide. But of course, politically speaking, for Gambia, even if the court does not find genocide, Gambia has there is going to be a lot of public attention on the case, and that of course is a purpose of its own. Just one little element of anecdote at the end. The Gambia versus Myanmar case is the first case in which social media played a role, because a lot of the evidence that the UN found about the involvement of the Myanmar army, the activities of the army, was the Facebook accounts, or let's say messages that were sent by the Myanmar armed forces by Facebook account. The Facebook accounts have, in the meantime, being shut. I'm not on Facebook, so I don't know how it works. But they said the accounts have been closed. But a few weeks ago, actually, I got an email from a US law firm And they said, Professor Simma, would you write us a legal opinion on that question? Because we are working for Myanmar, and the purpose of that opinion, or the aim that would be that it makes no sense to allow document production into Facebook accounts, because everything that Facebook messages can provide is already on the file. And of course, you can imagine that I said, no, thank you very much. I'm not going to do that. That much on Gambia against Myanmar. Now, at the end of this, let's say, investigation of human rights cases by the ICJ, let me turn to a special category of cases. These are cases in which one state bases its claim, among other things, on human rights. These claims are countered by the respondent state by arguments which are based on more traditional international law. And the court makes its decision, and the decision is not in favor of human rights, but the respondent wins the case by relying on the more traditional rules. And these are cases that turn around state immunity or immunity of state organs. That is, one state brings a claim against another state and says, you have breached the rule of international law. I'll get to the concrete cases in a second. The other state says, yes, but that act, that statement was done by a state organ, a minister of mine or somebody, and therefore that person enjoys immunity. We enjoy state immunity, jurisdictional immunity from before the courts of another state, and therefore what you have done is not permissible. There are two cases around in that regard, and the first case is the so-called arrest warrant case or Yerodia case. And again, we are in Belgium. Again, we have these eager human rights, eager juges d'instruction. What has happened? In the Democratic Republic of Congo, you remember the country from the cases I mentioned yesterday, had problems with its neighboring states. The neighboring states had entered the country with the consent of the DRC government, but in order to quell unrest in the country. But once that, let's say, the situation had been more or less brought to an end, these countries did not leave, because apparently on the territory of the Democratic Republic of the Congo, you find many things and resources that you would like to have for yourself. So they didn't go. And in that situation, a minister, the minister of the Democratic Republic of Congo, engaged in public speech in which he said, let's get rid of the Ugandans, let's get rid of the Rwandans. They are our enemies now, and go out and drive them away, and if necessary, kill them. And that was regarded by this Belgian juge d'instruction as a violation of international law, that is sort of called excitement to genocide, excitement to other human rights violations. And he got an international arrest warrant against that minister, Mr. Yerodia. And the Congo went to the ICJ and sued Belgium. And the ICJ found that indeed Mr. Yerodia, as a minister, enjoyed absolute immunity for what he had said. And therefore, the arrest warrant brought by Belgium against that person was a violation of the right of the Congo to see that its organs were not subjected to foreign jurisdiction. That the organ immunity, agent immunity, state immunity. That, of course, is typical. I mean, a human rights claim is countered by a claim based on traditional international law. And what that case shows is that the ICJ does not always decide in favor of the human rights arguments. There is one passage in that judgment which I'm going to read to you, because the court said at the end of that very unsatisfactory judgment, in my view, he said that immunity from jurisdiction enjoyed by incumbent ministers for foreign affairs does not mean that they enjoy impunity. That means immunity does not imply impunity. And then they say, because there are a number of conditions under which such persons can be sued before courts in other countries or before international criminal courts. And one of these instances, which the ICJ found, was a sign that no, there is no impunity. There is still a possibility to punish such people. Is phrased as follows, and I'll read that. The court said, thirdly, after a person ceases to hold the office of Minister for Foreign Affairs, he or she will no longer enjoy all of the immunities accorded by international law in other states. Provided that it has jurisdiction under international law, a court of one state may try a former Minister for Foreign Affairs of another state in respect of acts committed prior or subsequent to his or her period of office, as well as in respect of acts committed during that period of office in a private capacity. Now, of course, if we had a seminar with back and forth between us, my question would be, do you see a problem with that formulation? And I'm sure you would raise your hands and say, of course, because what is with acts committed by a foreign minister which is in office, committed not in his private capacity, but in the capacity of being a foreign minister or a minister of justice or head of state or whatever? And there the court makes no exception. It says the court does not, and you could say in a sense, the court does not recognize that such violations of human rights can be committed by persons in their official capacity. Because if you ask a country, has your foreign minister or has Mr. Committed has he, let's say, was there excitement to genocide or propaganda, etc.? They will always say, we have not done this. This is not done. And if somebody said something, he or she did that in his or her private capacity. But of course, the people don't do these things in their private capacity. They do because they are in a public office and they have the power, the authority to come with it in order to engage in such breaches of international law. So that is a very important lacuna in arrest warrant. And I remember when I was at the court, and then we started dealing with the Congo-Rwanda case, Judge Rosalind Higgins came to me and said, Bruno, this time we human rights lawyers on the court, we have to kind of rally together and see that judgments similar to that don't ever happen again before the ICJ. And that then led to this joint dissenting opinion against the finding of the court that unfortunately the reservation made by Rwanda excluding the jurisdiction of the ICJ was valid, so the court couldn't do anything. So the arrest warrant case is a very good example of let's say the victory of old-fashioned international law over claims on human rights. And the second case, and actually the last case on my list, is a case brought by Germany, that is my home country, against Italy. What had happened was that Italian courts, among them the highest court, the Corte di Cassazione, had rendered decisions which found Germany, the Germany of 2010, 2020, responsible for violations of human rights and violations of international humanitarian law committed by by the SS, the Gestapo, that is armed forces of Germany, from 1943 to 1945. Italy had begun in World War II as an ally of Germany, but in 1943 it had turned to the other side. So Germany kind of occupied the rest of Italy, and the German troops engaged in fighting the partisans, the vice versa. So terrible things happened also there. These cases were brought before Italian courts. And in the 1990s, the Italian courts, early 2000s, the Italian courts found that Germany had indeed engaged in these violations, that this led to responsibility by Germany. Germany had not done anything to compensate the victims of such crimes, and therefore would Italy please go ahead and claim compensation from Germany. Germany regarded these court decisions as breaches of the old established law, again, jurisdictional immunity of states, which means that no state can be brought against the domestic court of another state for acts that are not more or less of a commercial nature, the iure gestionis, but acts committed iure imperii, of course in square brackets, to describe war crimes, crimes against humanity, by the nice Latin title, Acts Iure Imperii, is a bit too much of a compliment to these activities. But the courts, and so Germany, the same things actually happened in Greece. There were cases of where the German armed forces during World War II had massacred entire villages in Greece, were brought before the Greek courts. The highest Greek court rendered the decision and said Germany does not enjoy, cannot rely on immunity for these acts. Then Germany, of course, there was diplomatic pressure, as you can imagine, and then through things that are a bit too complicated for me to really set out in detail, brought these cases to an end in Greece. And so the Greek claimants brought these cases, the judge and judgments rendered by the Greek courts before to Italy. How is this possible? Well, this can be done on the basis of European Union law. There are rules in European Union law whereby a judgment rendered, let's say, in Greece can be more or less executed, brought to execution in another member state of the European Union. So they went to Italy because they had learned that in Italy there was the same jurisprudence, and so Germany complained about the position of the Italian courts and the recognition by Italian courts of these Greek judgments that all went against the state immunity of Germany. Now, remember at the time there was a huge, let's say, expectation of the human rights community that there the International Court of Justice would have an opportunity to really come out in favor of that new international law of human rights against the state immunity, which Germany did not deserve in view of the crimes that Germany had committed in the 1940s. The ICJ had jurisdiction on the basis of a European Convention on the Peaceful Settlement of Disputes. And according to that treaty, the jurisdiction on the basis of that convention extends to, let me read it, because this is, there's the question of jurisdiction with regard to time, jurisdiction ratione temporis. And there the convention says, the convention, and that is the jurisdiction of the ICJ, is not given for disputes relating to facts or situations prior to the entry into force of the convention as between the parties to the dispute. Now, the convention had entered into force between Italy and Germany in 1961 only. Well, the convention was adopted, concluded in 1957, so 1961 is not really bad, 4 years after. But the important thing is you can only bring acts before the ICJ, which had facts or situations before the ICJ that had occurred prior to the entry into force, that is prior to 1961. And that meant that a lot of the things that the human rights community thought would end up before the ICJ and would be regarded as crimes and would be decided against Germany were not under the jurisdiction of the court. Namely, the question of the German war crimes, the crimes against humanity, the question of the duty of reparation arising from these crimes. The question, is there not just a reparation claim between at the level between the two states, but also claims to compensation by the individual victims of such crimes, the effect of comprehensive waivers. Actually, after World War II, Italy had declared a waiver and said, we are not going to claim reparation from Germany, among other things, for what they have done in our country, etc. That was not under the jurisdiction. So all the court could decide were what had happened after 1961, more or less meant the court had to decide about the behavior of the Italian domestic courts as such, not the reason why the Italian domestic courts had arrived at these conclusions in before. So the court went into a comprehensive study, really a very thorough study on the question, what is the state of international customary law on the matter? And it came to the conclusion that international customary law had was originally based on a comprehensive state immunity for acts committed by state organs in their public, as acts of public authority, iure imperii. And the court found that even though there were court decisions here and there around the globe, there no, let's say, practice, no general practice accepted as law had developed and had more or less eclipsed or done away with the traditional principle of immunity. In that regard, the court is founded the finding on what the International Law Commission has also found a few years, also while I was a member of the International Law Commission, that there is a UN Convention on Civil Jurisdiction Immunity of States. I think it's adopted in the early 2000s. That the European Convention got some kind of a second reading by the International Law Commission while I was there as a member of the Commission. And one of the questions before the Commission was, is there a new exception to state immunity for grave human rights violations? And the International Law Commission did a thorough study and came to the conclusion there are certain trends, but there is no universal trend yet. The cases where domestic courts have accepted states from immunity due to war crimes, etc., are rare. So the general customary law in favor of state immunity still exists. The ICJ has to render its decisions on the basis of Article 38, which is on the basis of treaties, customary law, etc. And the court had to decide according to the customary law that we have to apply. There is no new exception in customary law or anywhere else that we have to accept, that we have to respect. So the court said there is no exception due to the gravity of the violations. There is no exception due to the character of the prohibition of war crimes, etc., as use cogens, as peremptory rule. there is no exception simply because the recourse that these Italians had to their Italian courts was the last avenue, the absolutely last means to maybe arrive at the remedy. All that did not impress the ICJ, and it came out in the judgment as saying Italy has violated international law vis-à-vis Germany by the activities of its, or by the pronouncements of its domestic courts, and Italy has, by way of means of its own choosing, repaired that situation. So great outcry in the human rights community worldwide. Great relief, I have to say, with a little sarcasm, in the foreign offices among the diplomats of not just in Germany, but also in Italy and in other countries, because if the court had decided otherwise, in case of Italy, what would have become problematic would have been the Italian activities or behavior in Ethiopia in the 1930s or against Libya, where Italy had engaged in all kinds of crimes itself. But one interesting, or let's say, thing happened afterwards in 2014. In 2014, the Italian Constitutional Court found that the Italian Constitution obligates the Italian state to respect and ensure the basic human rights of its nationals. The Italian courts had actually acted in, let's say, in that respect, but the Italian state had declared that it would oblige, that it would implement the judgment of the International Court of Justice, and that act of implementation was a breach of the Italian Constitution, the very fundamental human rights of the Italians, according to the Constitution. And so the court said, if even found that the law, the Italian law by which Italy had incorporated into its domestic law the UN Charter, the Charter of the United Nations, that this Italian law was unconstitutional if Italy read the provisions of the UN Charter saying that decisions of the International Court of Justice rendered against Italy have to be performed. If such implementation were to extend to the judgments like the one they had rendered with regard to German war crimes, that would be a violation of the Constitution. Just a judgment which has created a lot of, let's say, a huge echo. I remember I a few years ago attended a conference on Lago di Como, Lake Como, because there's a beautiful villa there, Villa Vigoni, which belongs to Germany, and the Italian courts had already sort of selected Villa Vigoni as the German property into which their judgments on the responsibility of Germany for these war crimes would be executed. And at that, well, okay. I think, again, I'm running out of time if I go into details there. So much the jurisprudence of the ICJ. And now let me more or less come to the very last part of my lecture, namely what, after all these cases that we have heard, what is to expect? What are, do human rights really have a chance before the ICJ? Is it a good idea to bring these cases before the ICJ? If you bring such cases to the ICJ, what are limitations, what are obstacles, and the like? So let me just spend a few minutes on these matters. And I think most of these observations will be rather in the nature of sobering remarks. That is, don't put your expectations too high. Because, and I have 4 points to make here. The first point is, I would like to again emphasize the principle that the court's jurisdiction is not compulsory. It has to be established in each concrete case by an agreement of the parties. Now, if you look at the human rights conventions, the human rights treaties, let's say concluded by the United Nations, as the main bulk of human rights law that might end up before the court, you see that only a handful of these treaties provide for the jurisdiction of the ICJ. And there's only one human rights treaty which provides that states can go to the ICJ immediately. In the other few instances where the ICJ jurisdiction is provided, before you can go to the court, you have to engage in certain steps. And if you don't, let's say, if you don't set these steps in a sufficient way, then recourse to the ICJ is out. And you will remember the Georgia v. Russia case, in which the court found precisely that, namely that Georgia went to the ICJ, but did not beforehand engage in sufficient negotiation or attempts to settle the case peacefully with Russia. So, and of course, this is really an element that will be very important. That it will be very difficult to, let's say, find a human rights treaty which provides everything that you need in order to succeed with a human rights case. Gambia against Myanmar, Genocide Convention. Positive or opportune in the sense that it enables a country to go to the court immediately. But of course, the big problem with the Genocide Convention, as I've stated repeatedly, that genocide needs that you prove that special intent. And in my view, the chances of winning a case on the basis of a claim to genocide by the other side is minimal, therefore, because I mean, okay, you had Srebrenica, but that was only a very, very small fragment, let's say, brought before the court by the claimant states in the Bosnia and Croatia cases brought against Serbia. Second point, human rights violations. Human rights violations before the ICJ. Cases or contentious cases before the ICJ can only be brought by one state against another state. And in a way, we are looking at the wrong relationship there, because human rights violations viewed from the angle of another state can only bring to the fore very limited aspects of these problems. The court will look at human rights violations from the viewpoint of state responsibility. You read in the statute of the International Court of Justice, you will see that questions of state responsibility are questions that you put forward. For the court, human rights violations are matters of state responsibility. If you look at the law of state responsibility, it has been modernized by the International Law Commission to some degree. But if you look, for instance, at what the general law of state responsibility applicable by the ICJ, what that law provides with regard to human rights violations, you will come to the conclusion that it doesn't provide anything specially, let's say, tailored for human rights violations. What is the general law of state responsibility? The general law on remedies, it's satisfaction or reparation. Reparation in the form of compensation, that is, you pay money. It's let me say, compensation or restitution in integro. These are all remedies that are, you can see, have their basis in good old tort law. But tort law is not the ideal means to come to terms with human rights violations. If you compare what the ICJ had to say in the genocide cases on the possibility of remedying these violations. If you compare that with the jurisprudence of the Inter-American Court of Human Rights, for instance, where they really create bespoke remedies, or there are famous declarations by the UN General Assembly on compensation for human rights violation, etc., etc. You see that the ICJ has to work with a set of instruments in that regard, which is old-fashioned, which is tailored for relations between states. If Austria breaks an obligation against Germany, there will be an excuse, there will be compensation, there will be made more or less reinstatement, etc. But that doesn't help in case of human rights violations. The third point, states will very rarely actually engage in bringing human rights violations by other states before the International Court of Justice. Just read the newspapers. I think yesterday I mentioned the example of Hong Kong. If you look at the European Convention on Human Rights, for instance, which provides also for state applications, that is, according to the European Convention, only states can bring cases against other states for human rights violations. If you look at these cases, what you find is, first, they are very rare. Individual complaints, they go into the hundreds of thousands. State complaints are less than 2 dozens. Why? Because states simply, to bring the human rights violations by states before an international court or before the United Nations, in almost all instances presupposes that there is a special situation around that, or there is a special relationship between engaged here. For instance, the very first state application, state-to-state case brought on the basis of the European Convention was a case brought by Greece against the United Kingdom, and it had to do with Cyprus. And of course, you see, okay, Cyprus, majority population Greek. What did Greece complain about? Complained about the treatment of Cypriot freedom fighters against the British before Cyprus was released to independence in around 1960. So that the British fought the freedom movement on Cyprus, and Greece took up that case. Or you might have heard about the cases brought by Ireland against the UK in the 1970s due to there was this, let's say, civil war almost in Northern Ireland. There was very, very, let's say, forceful combat against by the British armed forces in Ireland. And so Ireland brought a case claiming that the British armed forces had engaged in torture, etc., of Irish freedom fighters. So in almost all cases, you find an element, I am claiming human rights violations in another country, but if you look closely, you see they belong to the same ethnicity. Greek case. They are Irishmen like we, Ireland against the United Kingdom. And also in Gambia versus Myanmar, you see the link of religion. Gambia, as a country with a Muslim majority, goes against a country with a majority population which is Buddhist, and the violation is breaches committed against the Islamic minority, to which you somehow feel have a certain relationship. And it's very, very rare to come across a case which is, you might call it a pure human rights case, in the sense there is no traditional element of allegiance or alliance between the victims of the human rights violation and the state going to the ICJ. Maybe Belgium against Senegal in that regard is even quote unquote purer than the Gambia against Myanmar case. And And the fourth point is very simple. Before the ICJ, states make claims, and the International Court of Justice has to be very careful not to step beyond, not to go beyond in its decisions over beyond the claims of the parties. You will have heard the saying, ne eat judex ultra petita partium. And so whether human rights claims will be made or how forceful they will be made will all depend on the state's parties. And the court is, in that sense, is in the hands of the state's parties. And states are, for a number of reasons, not really keen, except if you go against a political opponent, you want to hit that state with every argument you have. And you say, and besides number 7, the guy is also a very bad human rights violator. So that's all very negative. But so isn't there something more positive to say? And of course, positive things are there, namely the human rights genie is out of the bottle, so to say. I mean, you have more and more human rights law. Human rights considerations permeate let's say, are visible in more and more areas of international law. And so I think it will just be inevitable, unavoidable, that you will have human rights cases also in the future. So human rights arguments will continue to be made. And maybe a special observation ought to be made here with regard to advisory opinions. I have really focused on contentious cases until now. But of course, I've also mentioned, and a lot of the cases that I have mentioned have actually been not contentious interstate cases, but advisory opinions rendered. And in advisory opinions, the court is much freer and it can refer to law, it can apply law, even though the parties, and of course, sorry, you don't have parties in case of an advisory opinion, but you have states which appear. For instance, in the Wall opinion, I remember there were scores of states appearing before the ICJ and pleading, not as parties, but just as every member state of the United Nations can go before the ICJ in a proceeding on an advisory opinion and state its view. And many states do. But even arguments that are mentioned by neither of these states can be, let's say, used by the court in advisory opinion. The court will be very careful in this regard, but it's not something that must not be done. And so my expectation would be that it will be particularly in advisory opinion proceedings that the court will make let's say, strong statements on human rights matters. And then the last question will be the following. Is there something, I mean, we have now a whole series of international organs, of international institutions, of international courts dealing with human rights matters. You have regional courts, particularly regional courts, Inter-American Court, European Court, African Court, and then you have the ICJ. Is there some kind of consequence to draw from that state of affairs? And I think one thing that we should conclude from this is that the court should be very cautious in the field of human rights, because you have a large and very, let's say, thorough and very carefully crafted jurisprudence of regional human rights courts on almost all basic human rights. And if somebody steps in from the sideline, as the ICJ, willing to also engage in human rights discourse, that the ICJ will have to be very careful not to lead to, let's say, to a lowering of a standard which has been achieved at the regional level. So one could say that engagement of the ICJ with human rights is a bit of a double-edged sword. It brings, on the one hand, it brings recognition and respectability to human rights. within the mainstream of public international law, but on the other hand, it may also do so at the cost of curtailing the substance of international human rights law that was established and fought for by regional human rights courts. And I think the court is actually very careful in that regard. It is conscious of that problem. So what then is a proper role for the court? Something that the court can do better than other courts. And in my view, there is such a proper role to be found, namely in what I call the juridical mainstreaming of human rights. Human rights, that is, the ICJ is an organ which is, let's say, singularly capable of mainstreaming rights in the sense of integrating this branch of human rights law, into the fabric of general international law. So the court, you could say, human rights claims arise in very different ways. And at some stage, they are claimed also in legalistic terms. And maybe human rights claims will find will have an impact on, let's say, general comments of UN human rights treaty bodies. I've been engaging in devising such general comments for 10 years in my Committee on Economic and Social and Cultural Rights. But when you look at these general comments, they're very valuable and they have a high authority, but it's very difficult to say, for instance, you have a general comment on the right to water, on a core obligation with regard to social security, etc. To see now what is precisely, is this all the law? If they set out something which in the human rights treaty is written down in one sentence, and the general comment comes out on 5 typewritten pages, is this all supposed to be the law? Is this an interpretation, or is it something that these bodies kind of attach to a core international legal obligation proper? And in that regard, of course, let's say borders are very, very difficult to draw. But you could say that once the ICJ has taken up such a human right and has defined what it contains, has determined the limits, you could say this provision of human rights has gotten, let me call it, the ultimate blessing from the viewpoint of international law and the appliers of international law. And one special group in that regard would be when the court finds, let's say, solutions for practical, more technical problems arising in connection with human rights. For instance, I would consider a decision by the International Court would be very valuable with regard to the problem of reservations to human rights treaties. One of the big, let's say, very fashionable topics in recent years, reservations to human rights treaties. We have International Law Commission work. Part of that law of reservations is quite controversial. And if you had a word by the ICJ in that regard, that would be extremely helpful. So, final statement. So if you wanted to find a short-term description of the current status of human rights before the International Court of Justice, one could say this is an instance of international legal discourse in which the old international law, represented for our purpose by the court, encounters the new international law, which is the law of human rights. And what we can observe already is that the court has become a major player in a process in which human rights and general international law mutually impact upon each other. Human rights modernizing international law, but international law on its part mainstreaming human rights law. Thank you very much. I'm ready now to answer questions. I thank you for your attention. So let's see what we have by way of questions.
Thank you, Professor Zima. I thank you very much for giving us an instigate overview about the jurisprudence of the ICJ, answering the question of what proper role the ICJ should have in human rights issues, what the ICJ must be able to do better than specialized courts. As Professor Zima said, the task of the ICJ is not easy. Its compulsory jurisdiction depends on states. ICJ was created precisely to settle interstate disputes. Only states can sue each other before the court. And of course, it's not surprising that in the past, some of the court's most important contributions to international human rights have been made through advisory opinions. But as Professor Zima concluded, the ICJ can render human rights arguments more, how can I say, acceptable to international law generalists by interpreting and applying provisions of treaties in a way that states can accept. Now we come to questions. We have just 20 minutes, and I will pick 3 questions or just one at the beginning to be answered at a time. The first one is from Fernando Porto de Sá. Professor Zima, even today, we see little dialogue between the ICJ and regional courts. For instance, the Inter-American Court on Human Rights, even when both deal with very similar themes, like in the consular rights case. Should the court, the ICJ, be perhaps more proactive in bringing in not only human rights rules, but also judicial practice into its judgments? Professor, the floor is yours.
I think the question can be divided up actually in 2 separate questions. The one would be is what kind of connections or discourse or do we have between the ICJ and human rights courts, which are by nature regional. And the second would be judicial practice in a wider sense, right? Okay, let me try. Well, maybe the first thing to say is that the International Court has been very, how should I say, selective in choosing dialogue partners. Actually, until very recently, it has been so selective that it didn't engage in dialogue with any other organ. Let me see, maybe I mentioned yesterday that little anecdote when maybe I can put it in a bigger context so it becomes visible what I mean. This was the case of Congo versus Uganda. And in that situation, what you found was that armed conflict only went on in one region of Congo, namely in the northeast of Congo. And so but certain things happened in Kinshasa, which is at the other end of Congo, namely at the Atlantic Ocean. And there's, I think, 1,500 kilometers in between. And so the question was, now, if you have to apply rules of international humanitarian law in the war zone, are these rules also to be applied in Kinshasa, when you don't hear any gunshots and etc. And I had found a beautiful case by the ICTY, which had come to the conclusion, well, if armed conflict only, let's say, affects a part of the territory of a country, the law of armed conflict will apply in the entire country. And I was very proud in a drafting committee, and then I was told by the registrar, by the former registrar of the ICJ, who looked at me and said, well, Mr. Zima, we never referred to other international courts. Why? Because, and now I kind of speak for the court in a sarcastic way, because we are the oldest court. We are the principal judicial organ of the United Nations. We are the world court. therefore we are the most important of these international courts. And what do we care about these minions, ICTY, ICTR, or even ICC? Courts that more or less were established by a resolution of the Security Council. Look at us. We are really the first rate. It's about like the European Court of the European Court of the European Communities, which is almost biblical and says, "Thou shalt not have another God beside me." And that is also a bit more modestly the position of the ICJ. Don't quote me when you meet colleagues, or don't quote me to Professor Cansado. But there is a bit of that there. And this only changed very, very, let's say, gradually and hesitatingly in the Yugoslavia case, because there, with regard to Srebrenica, etc., the ICJ found I have no separate own means to engage in fact-finding. So I really have to accept what these people up there in this lower court, ICTY, have found. So, okay. Then I remember there was a meeting we had with judges from the European Court of the Court of Justice of the European Communities in Luxembourg. There was a meeting, and it had to do with the problem: to what degree is the European Union a legal person in public international law, and to what is it bound by Security Council decisions, etc., etc. You might have heard the term CADI, the CADI problematic, where the European Court of Justice said, we are not going to admit the effect of certain sanctions by the UN Security Council if these sanctions affect an individual within the European community in his or her basic human rights. So the ICJ will be very, very careful in that regard. There was another case actually that almost made it to the court. It was a case brought against between Switzerland and Belgium, which had to do with Sabena, with the Belgian airline. And the case was finally kind of suppressed because the European Court would have had to take up questions of European Union law, European Community law, and therefore the European Community, and especially the EC Court, the European Court of Justice in Luxembourg, was not interested at all in some competitor in The Hague taking up questions on which it claimed to have the last and decisive word. So, which means the lack of intercourse, the lack of discourse between international courts also has to do with what you could call every court has its own turf, and every court is very, very keen on protecting and preserving its turf. There are questions of the, let's say, relationship, the hierarchy, the rank between certain regional institutions like European Union and public international law. So decisions by a court belonging to one group on the law of the other group might be problematic. This might have political repercussions. Sometimes it's also very personal. I remember I have a good friend who is a member of this is not a regional human rights court. It's the German Bundesverfassungsgericht, the German Federal Constitutional Court. And I have a good friend there who is a judge there. He was my assistant, Andreas Paulus. So I said, "Hey, why couldn't we engage in a visit? Either we come to you or you come to us." And he found that a good idea, but then he came back to me and said, "Well, unfortunately, I spoke with our president, and there are problems of protocol. Who should invite whom? Would it be if you invite us? Would that mean that you more or less very grandly invite us as a lowly creature, etc.?" So nothing came out of that visit. So there's a lot of very, how should I say, human psychological reasons there also. You have the European, I don't know about the Inter-American Court. Of course, I'm closer to the European Court of Human Rights in Strasbourg, and they are proud on decisions on questions of general international law. And I would say, I have done a little studies of these questions. You would say there is no real, let's say, a difference, or there is no problem to see in the way in which the two courts look at international law. Strasbourg looks to The Hague, and in the Diallo case, The Hague looked at Strasbourg. There will of course be more opportunity for the Strasbourg court, or maybe also for the San Jose court, to look to The Hague, because they will more often deal with questions of general international law surrounding their conventions than the ICJ will have with regard to the European Convention proper. Actually, also in square brackets, there is some kind of a consensus among European countries that they, especially members of the European Union, that they should not, if not really necessary, should not bring cases they have against each other before the ICJ, because that would be something against that the appearance of the European Union member states as forming a very, very, let's say, intense group of states. That do we need the ICJ, to which Myanmar, Mali go? Do we need them to settle a dispute between Austria and Switzerland? Rather not. So maybe these are things that come to my mind with regard to that, the first part of that question. Should the court base itself more on judicial practice? Now, if the person who asked that question understands that in a certain sense, then I've already answered it. That means, should the court, let's say, take into consideration the judicial practice of other courts that I have dealt with? And maybe I'll just formulate another bottom line. I think such engagement with the jurisprudence of other courts is slowly increasing. Maybe not as a question, as a matter of love and affection for other courts, but just out of necessity because of the growing specialization of international law. There's a general court, a generalist court like the ICJ, will simply not get around referring to what more specialized regional courts have said about certain matters. So I hope this is a not too exhaustive answer to that first question.
Thank you, Professor Zima. And the second question is from Fabio Farinella. Dear Professor Zima, do you think that a violation of a jus cogens human rights extends its effect to the procedural norms that are used to protect it, and therefore no reservation related to jurisdiction or immunity could be recognized by ICJ?
So if I may kind of turn this question around a little bit and put it into my own words. So it seems to be, so you have human rights, and you have dealt with human rights for 3 hours almost now. So what do you mean when you say erga omnes obligations are rising from it, or human rights norms are being have the nature of jus cogens, which is peremptory rules which cannot be contracted out from, etc. Or the alternative view would be, would we have to distinguish between a core of human rights, and maybe you could determine that core of human rights by looking at the provisions in human rights conventions, like Article 27 in the American Convention, or I think it's Article 4 in the European Convention, which deal with states of emergency, and then say states may, in emergency situations, say that we are going to suspend the granting of these rights under some international supervision, with the exception of obligations 1, 2, 3, 4, like right to life, etc., etc. Wouldn't that be some kind of a sign or a marker of the jus cogens nature of these rights? And I think indeed that is a very that is a very pertinent question. I think there is quite a bit to that you see, if you want to find the core human rights obligations, look at these state of emergency provisions. Hopefully you will find them, but not very few conventions. For instance, the Torture Convention does not have provision of that kind. But of course, you find in the General Convention, you find the prohibition of torture. But then, does that really extend into the nooks and crannies of a human rights obligation, or is there some kind of a core and some margin around? And of course, I think that is a very important question. In the very first paper I wrote in my life on breach of treaties, I mentioned an example stemming from IHL, according to which in the treaty law, on probably also customary law nowadays, on the treatment of prisoners of war, there is an obligation that a prisoner of war has the right to write. I think in some could have been an earlier convention at the moment, to write a postcard every 2 months to his family, and that postcard will be actually brought to the other side in the war, etc. And now let's say that the state decrees that, well, instead of being entitled to write such a communication to one's family every month, you're only going to have that right every 3 months. Would that be a violation of the Jus Cogens content of that human rights rule? Second approach to the problem. I remember I had to do with the German Foreign Office for a number of things, more or less on a frequent basis. And I remember sometimes you had people from the Ministry of Justice sitting around the table and discussing matters. And there were times when especially the Ministers of Justice and the Ministers of Interior were quite furious about the jurisprudence of Strasbourg organs. For instance, on matters of, is there a limit to penalties rendered in case of road traffic violations? So if you read some of the jurisprudence of Strasbourg organs, you think, oh my God, I would love to have these problems. The problems Western Europeans have. Look into these details. That is, human rights is kind of settling down into areas where you would never assume that human rights have a place. I remember there was a famous case, one of the leading cases in European Convention law. I think it was the Tyrer case, which had to do with punishment that was meted out on the Isle of Man, which had to do with birching. People were beaten by birches. I mean, I think the Finns do it as a matter for pleasure in their saunas, etc., but most people wouldn't like it. And the then British judge in Strasbourg kind of cried out and said, is this a matter of human rights? Listen, human rights, this is when at 3 o'clock in the morning, somebody, let's say, opens your door with their feet and drags you out of bed, and then you are never seen again. This is human rights, but not these ridiculous things. And of course, he was wrong. I mean, in the specific case, but the question, I think, is a legitimate one. And so my answer to the question put by our student would be, I think you need to distinguish between a core of human rights, and you can only, let's say, put all these qualities like Jus Cogens, erga omnes, etc., on a core. But please save me to determine the core, aside from the, let's say, observation like state of emergency provisions as a as a marker, etc., etc. I think nobody has come to a clear distinction in that regard. But fortunately, at the international law level, the human rights, fortunately or unfortunately, actually, that come up at the international level before courts, etc., are very massive, very flagrant, very, very, let's say, grave violations of human rights, where that question does not play a role.
Thank you, Professor Zima. I think that we have enough time for just one question. What do you think? Okay? Okay, sure. So I choose just one. Professor, a question from our student, Leticia Hartel. Professor Zima, could you comment on the possibility of having a judgment by the ICJ clash with a judgment by a human rights court, such as what could have happened in the case certain property Liechtenstein against Germany? What will be the consequences of such a scenario? Our last question.
Mm-hmm. So I'm not sure whether the entire audience, most people stemming from Latin America or Brazil, are very familiar with the Liechtenstein property. So this had to do with what happened in Czechoslovakia at the end of World War II, when the German people of German ethnicity were evacuated, had to leave the country, and German property was confiscated by the Czech state. One of the people suffering from this was the Prince of Liechtenstein. I mean, they claim that they have their own country, they are a sovereign state, which they are, but the Czechs regarded the Liechtenstein family as persons of German nationality, and they lost their property in Czechoslovakia. Now, years later, some lawyer of Liechtenstein discovered that the paintings that had been taken from Liechtenstein in 1946, etc., were shown at an exposition in, I think, somewhere in Germany. And so, of course, they went to the German courts, and they went to the Strasbourg Court of Human Rights, claiming that this is our property. It has been taken in breach of international law, and therefore it has to be restored, etc. And one of these claims was brought to the European Court of Human Rights in Strasbourg. But, you know, when you look at the European Court of Human Rights jurisprudence, you see that it has a device there, which, so I'm not a world expert on the Strasbourg law, but there is a principle that if an alleged or claimed human rights violation is committed, and there are some very cogent, very important policy considerations behind, or let's say international law considerations behind, then that human rights violation will just has to be accepted or tolerated. And that is precisely what happened with the Liechtenstein property. The European Court of Human Rights said, we have to see that these instances, these facts, date back to World War II, they date back to really high-level political problems and agreements after World War II, etc. And that is, we have to respect that. So we are not going to in that and regard that painting that Liechtenstein claims belongs to it like a painting that was taken by the state of let's say Germany from somebody from a German owner, etc. So and this is something which you encounter actually in one of the cases also, at least in one of the cases that I mentioned, namely in the state immunity cases. Like the Greek courts come to the conclusion there is a violation. Germany has violated. Germany doesn't really deserve immunity. Then they go to Strasbourg because the Greek state somehow suppresses that development. And I think Strasbourg decided more or less along the same lines like in the Liechtenstein case. They said this is World War II stuff, etc. And there are reasons for which we kind of give priority to these considerations, these high interstate diplomatic public international law considerations. They enjoy priority vis-a-vis the claims of the individual whose rights have been violated. I think that's as much as I can say, just out of my cuff. And I hope this has been at least satisfactory to some degree. Since time is up, let me just say how much. I mean, pleasure is a matter of degree. And I have to say that my lectures to people physically present and sitting in front of me in Belo Horizonte 15 years ago were more pleasant. I remember there was a guy who looked at me all the time, and then I just asked him and said, "So what is there something wrong?" And then he showed me that he had on a piece of paper, he had drawn a beautiful caricature of myself. Which was really very well done. And he said, well, we are having great fun. So I don't know whether anybody has drawn a caricature, but unfortunately, I'll never be able to see it. So being together physically is, of course, different from just looking at a screen and not seeing you. But I think it's better than nothing. And I think this is really one of the very few positive effects of Corona. You can from my desk with my grandchild right behind, I can give you a lecture and you are in Brazil or in Myanmar or whatever. This is also wonderful. So it was a pleasure. I hope you found interesting what I said. And I wish you, let's say, happy life, great careers, and above all, watch out. Be very careful about the coronavirus, especially in Brazil. So take care and obrigado.
Thank you very much, Professor Zima. I'm very grateful for your instigating lecture. Will be certainly generate much reflection for the students who see us. And of course, we come to the end of our lecture, and I would like to acknowledge the brilliant organization work done by Professor Leonardo Nemer and the CEDIM team on behalf of Paula Neves. Thanks to everyone, the audience, and especially thank you for the questions and for the attention. Bye. Bye, Professor Zima.
Bye-bye. Bye-bye.